Namaste everyone, my name is ANAND, and in the previous session we have discussed about subjective principles of jurisdiction in occurrence of computer crimes. Now in this session we will try to discuss about application of effects doctrine in computer crimes. So this is also known as consequence or terminatory theory. So the principle is that where an act is done abroad and the criminal effect is produced here, the crime is to be committed here. Both English and American courts have exercised this kind of extraterritorial jurisdiction. To give you an example, in the case of Simpson versus State, the victim was in a small boat near the Georgia side of the wide Savannah River Simpson River. Simpson, the defendant, stood on the opposite South Carolina bank and fired several shots at the vessel. Now the bullet missed the boat but struck the water nearby. The Supreme Court of Georgia held that jurisdiction attached with these circumstances and that Simpson could properly be prosecuted in Georgia even though the defendant was clearly in another state at the time of shooting. The location of the victim and the place where the bullets landed established the basis for this decision. In another case, namely Orr versus Oliphant, in which a man in Paris, by false returns, caused incorrect figures to be entered in the account books of his firm in London. Now, it was held that the office of false accounting was committed by him in London. Now, if the principle of jurisdiction by effects theory can be accepted in relation to crimes like cross-border killings or conspiracies or false representations, then with the internet giving a much wider and global scope of committing crimes, providing for a global jurisdiction to tackle with the crime can be well justified. Now, under the Indian criminal law, Section 179 of CRPC embodies the effects doctrine, which reads offences triable where act is done or consequence ensues, and states that when an act is an offence by reason of anything which has been done and of a consequence which has ensued, the offence may be inquired into or tried by a court within whose local jurisdiction such thing has been done or such consequence has ensued. Now, Supreme Court of India in the case of State of Madhya Pradesh and Suresh Kaushal has held that Section 179 of CRPC contemplates two courts having jurisdiction and the trial is permitted to take place in any one of those two courts. One is the court within whose local jurisdiction the act has been done, and the other is the court within whose local jurisdiction the consequence has ensued. So, to give you an example, it is well settled that where a substandard article is sold, an offence is committed. The place where the same is marketed will equally have jurisdiction to try an offence against the manufacturers as well as the distributors. Section 179 contemplates cases where the act is done and its consequence happen to be in two different jurisdictions and provide that in such case the offence constituted by the act and the consequence may be inquired into or tried in either of the two jurisdictions. So, in an Indian case of this nature, person A at Karachi was making representations to the complainant at Bombay through letters, telegrams, and telephone talks, sometimes directly to B and sometimes through a commission agent. Now, B parted with money in good faith of these representations, which were false. The Supreme Court held that the representations were made to B at Bombay, notwithstanding that A was making the representations from Karachi. Hence, the entire offence took place at Bombay because it has been effected or consequenced at Bombay. Not merely one ingredient of it, which was consequence of false representation, namely the parting with the money by B. But the Supreme Court held that the offence would be triable both at the place from where the false representations were made as well as where the parting of the property took place. And to give you the name of this case is known as Mubarak Ali Muhammad versus State of Bombay. Now, Section 179, giving statutory recognition to the effects doctrine, is squarely applicable in computer crimes cases. There would be many situations where we would find that though the initiator of an illegal action is somewhere outside the territory of India, the effect of his digital wrongdoing has caused damage to persons within India. Such persons, by operation of Section 179, are liable to be tried in India. The Indian courts would have jurisdiction to try such cyber criminals. Now, the concept of effects doctrine has been recognized not just by India but by other countries as well. Its application in computer crimes has to be adopted as of necessity due to the peculiarity of the internet, which permits initiation of the crime from any part of the world, with its consequences or terminating effect in any part of the world without any barriers. Now, let me tell you something about Convention on Cybercrime, that is Council of Europe. Now, the Cybercrime Convention of the Council of Europe prescribes for the issue of jurisdiction in Article 22. It requires that every member nation should adopt legislative measures to establish jurisdiction over any offence established under the convention. Now, when the offence is committed in its territory, the nations have further option to establishing jurisdiction in case the offence has been committed on board of a ship flying the flag of the party or on board an aircraft registered under the laws of that party or by one of its nationals. Now, if the offence is punishable under criminal law where it was committed, or if the offence is committed outside the territorial jurisdiction of any state, it should be noted that the above convention that I told applies the theory of subjective territoriality and nationality theory, but avoids the effect doctrine. That is why it is not so much popular. Now, let me quickly tell you something about applicable law in computer crimes. Now, once the court has assumed jurisdiction, the next question is what body of substantive law should be used to resolve the problem? It is the substantive criminal law of a country which declares whether a particular activity is a crime or not. Every country has its own set of criminal laws. What is a crime in one country might be an innocent act in another. Online activities create a vast scope for confusion. It might even act as a haven. So, an offender can skillfully carve out a niche for himself in the cyber world where he or she is not answerable for his or her criminal conducts because of his or her physical presence in a country whose cyber criminal laws are not matured enough to pin him or her down. In India, the Information Technology Act delves deep into the issue of applicable laws in computer crimes. It clarifies that any act which is committed either within or without India would be illegal if it is an offence under the Act. To begin with, subsection 2 of subsection 1 of the Act states that it shall be extended to the whole of India. It applies also to any offence or contravention under committed outside India by any person. Further, section 75 of the Act provides for an act to apply for offence or contraventions committed outside India. The above two provisions makes it crystal clear that the offence, though committed outside India, is punishable in India. Thus, for example, a Nepalese sitting in China initiates a distributed denial of service involving computer networks in India to obstruct Yahoo email services. Such a person, if put to trial in India, can be found punishable under the IT Act. It is only because of the broadly drafted provisions that I just stated. Now, the certain provisions of IPC also suggest applicability of its provisions to illegal actions committed outside India. However, they are subjected to certain conditions. Section 2 of the IPC deals with punishment of offences committed within India. So, this poses no problem. If an illegal act concerning computers is committed within India, and it is the provisions of the code which would apply to such acts. Now, Section 3 of IPC reads punishment of offences committed beyond but which by law may be tried within India. Section 4 of IPC calls for nationality doctrine. And Section 5, I think, if I'm not wrong, Section 5 or Section 4, that has to be checked right away, uh, calls for extension of code to extraterritorial offences. Now, with this, I think completed the issue of jurisdiction within the premises of India and within the premises of cyber law, and how IPC, CRPC, and Information Technology Act combined with combined effort trying to do away with the issue of cyber crimes. What are the various issues related with jurisdiction? How jurisdiction is creating a problem for India? How Simpson and Oliphant has been applied in Madhya Pradesh versus Suresh Kaushal and Bombay case. So, after reading it all from the previous session and from the current session, we effectively know dispute resolutions in cyberspace. At least that I hope. So, in coming sessions, we will try to learn something about appellate tribunals under Information Technology Act and intellectual property measures in Information Technology Act. So till then, thank you very much.